Hello and welcome to Awareness Self-Directed Learning. And the topic today is the Nova Scotia Occupational Health and Safety Act. And this is one mini module in a multi-module session. So it's mini module 6 we're doing today, and we're covering sections 43 to 46. And you can see that we're halfway through the 12-module program. So the right to refuse. An employee may refuse to do any act at the employee's place of employment where the employee has reasonable grounds to believe that the act is likely to endanger the health and safety of themselves or that of any other person. So they can refuse work until one of the following three things happens. The employer has taken immediate action to satisfy the employee's concerns. The JOSH committee, if any, has investigated the matter and unanimously advised the employee to return to work, or an officer has investigated the matter and advised the employee to return to work. So we're going to go through the whole process around right to refuse, but I think the important thing to remember is that it's the employee believes. So it's not, they believe, and so you have to go through the process and making sure that you satisfy them that there's not a risk, or you do the investigation through the JOSH committee. So when an employee exercises their right to refuse, the employee shall immediately report to the supervisor. If the matter cannot be remedied to the employee's satisfaction, report it to the safety rep or the JOSH committee. And sometimes this reporting may be done jointly or individually. The supervisor may report it as well as the employee. And if the matter is still not remedied to the employee's satisfaction after it's gone through the JOSH committee, then it's reported to the Department of Labor and Advanced Education. The employee who refuses work because it perceives that the task will endanger the health of themselves or other, may choose to accompany an officer, safety rep, or the JOSH committee on a physical inspection of the workplace for the purpose of ensuring others understand the reason for the refusal. So this may happen a few times through the process. It may be the employee and the supervisor when they're talking about when the employee first brings to the supervisor's attention that there's a concern, they may have to walk the area and go through exactly what the concern is. Although a work refusal doesn't have to be in writing, it is a good idea to have the employee write down exactly what it is, that the reason for the refusal. Because a lot of times by the time it's going to the committee, there's been lots of conversations back and forth, and this allows for clarification on what still the outstanding issues are, because in many cases there's multiple things influencing it, and some you get resolved and some you don't. So clarify exactly what the issues are, and that's really good for the committee to start to understand what it is that is the concern of the employee. The safety committee then may do an inspection of the area and may want the employee there. And of course, if the Department of Labor gets involved, there may be additional inspections. An employee who accompanies the officer or the safety rep of the JOSH committee will be compensated for their normal wages. An employee who refuses to do work can be reassigned to do other work by the employer. The employee shall accept the reassignment until the employee is able to return to work. That's based on that it's been satisfied by the employer's perspective or by the JOSH committee, there's been a unanimous vote, or by the order of the Department of Labor. Where an employee is reassigned to other work, they should be paid the same wage, salary, and granted the same benefits while they're doing this other work. If an employee, if the employee has refused to work and cannot be reassigned, they shall receive their normal wage, salary, benefits as if they had continued to work. A reassignment of work of these types of situations are not to be considered discriminatory. An employee may not refuse to use or operate a machine or things or work in their place where the refusal puts the life or the health and safety of others directly in danger. The danger is accepted as being always present at that type of work in which the employee was hired for. So restrictions on assignment of work where there is a refusal. So where an employee exercises their right to refuse work, no employee shall be reassigned to do that work unless the matter has been dealt with, i.e. remedial action. It's been investigated by the JOSH committee or an officer has investigated, unless the employee to be reassigned to work has been advised that there's been a previous work refusal, the reason for the refusal, and the employee has the same right to refuse. So you just can't reassign work that somebody doesn't want to do and not let them know that there is a work refusal and the reason for the work refusal. And many times the work can be reassigned to somebody else, especially if it's been a lack of experience or training or knowledge, and there's other people that have more experience and knowledge in that area. But typically, if it's been refused for other reasons, like there's a safety measure that's not in place, most likely the next person's not going to want to do it either. But you have to, the notification ensures that people get all the information they need. The Act states that discriminatory action is an action that adversely affects an employee with respect to the terms or condition of their employment and any opportunity for employment promotion, and includes dismissal, layoff, suspension, demotion, transfer of job location, change in hours of work, intimidation, imposing of any discipline, or any other penalty, including reduction of wages, salary, other benefits, elimination of the job. So basically what it's saying is that if someone puts in a work refusal, it can no way negatively impact their employment. And even if it's found not to be the employee or the committee determines that it's not really an unsafe situation and they can return to work, there still should be no discriminatory action, because it is in that time when the employee put it in, they believe that it was unsafe, and we have to respect their decision to do that and put that work refusal in. No employer or union shall take or threaten to take discriminatory action against an employee because the employee has acted in accordance with the Act or regulations, or an order or direction, or has sought enforcement of the Act or regulation because of the participation of the employee in or association with a committee, or the employee has sought the establishment of a committee or performed functions as a committee member. Because of the association of the employee with a safety rep, or an employee has sought the selection of a safety rep or performed the function of a rep. The employee has previously refused work due to a risk to their health and safety, or the employee has sought access for information in which the employee is entitled to under the Act or the regulation and has been assigned to the role to observe. So besides the work refusal, in your function as a committee member, or if you're seeking information as an employee on any testing results or information that are discussed in the Act, there can be no discrimination or punishment or effect of their employment simply because they've asked for the information. No discriminatory action shall be taken on an employee who has testified or is about to testify in any proceeding or inquiry related to the Act, has given information to a safety rep, the JOSH committee, or an officer or another person concerning the administration of the Act or the regulation in respects to the health and safety of the employee at the workplace, unless the employer or union establishes that such action is solely motivated to legislate for legitimate business reasons. So again, this is making sure that employees can speak freely and are in no way negatively impacted by providing information. The right to complain. This section covers employees who are union and non-unionized who filed a grievance appeals. An employee who complains that who complains that an employer has failed to pay wages, salary, pay, or benefit entitlement, an employee or a union has taken or threatened to take discriminatory action, has different options depending on if they are union or non-unionized. Where the employee is not subject to a collective agreement under which the employee is entitled to file a grievance within 30 days, makes a complaint in writing to an officer, or where an employee is subject to a collective agreement under which the employee is entitled to file a grievance, have the complaints dealt with by final and binding arbitration under the collective agreement or within 30 days, take a complaint in writing to an officer. If an arbitrator is not used over the matter or under the collective agreement, which in this case, the matter may be dealt with by an arbitrator under the collective agreement. So to sum it up, if you're a unionized worker and there's a grievance process, you need to go through that based on what your collective agreement says. And if you're not subject to a collective agreement, you can put a complaint in within writing to an officer if you have a concern, and that is there as an entitlement. When an officer receives a complaint related to a previously mentioned situation, so a grievance or a complaint, the officer shall investigate the complaint and issue an order specifically specifying the provision of the Act or the regulations that there's been a contravention to, or determines that there is no grounds upon which to issue an order. So when the Department of Labor comes in, one of two things are going to happen. They're going to determine that there is no issue and they won't write an order, or if there is an issue, they'll issue an order and specify what part of the regulations are not being followed. Where the officer determines that an employer has failed to pay wages, salaries, or benefit entitlement required by the provision of the Act related to the activities of a JOSH committee, the officer shall require that to be done by a specific date. The employer is to pay the wages, salaries, and other benefits required, or the employer or the union to do the things and the options of the officer are necessary to ensure compliance with the Act and regulations. Where the officer determines that discriminatory action has been taken or threats against the employee, the officer's order shall require by a specific date. So this is if the employee has refused to work, or in their role as a JOSH committee, their employment is somehow negatively affected, and the officer determines that there's been some type of negative effect, then the employer who pays any wages, salaries, or benefits that the employee should have earned but for discriminatory action, and that any other reference to the manner in the employee's records be removed. So if there's been any statements or any reports put in around this, then that needs to be removed. The reinstatement of the employee to the union and the payment of the and repayment by the union of the employee's any wages, salaries, or benefits that the employee would have earned if it were not for the discriminatory action, and the employer or the union to do the thing that, in the opinion of the officer, was necessary to ensure secure compliance with the Act and the regulations. That is the completion of mini module 6. Please complete the post-assessment. When you fill out your answers, if you get the message of try again, it means you've gotten one or more of the answers wrong. Please redo the test and resubmit. Once you have them all correct, it'll thank you. And once you've completed all 6 mini modules, you will receive a certificate.